And I'm only here very briefly, but I'm definitely excited. I'm really excited to kick this off, partly because I want to tell you a really quick story. I owe my job to a presentation just like this one. So I was an analyst. This has got to be over 10 years ago at Otis College. I was teaching at the time, and it was a panel on intellectual property and intellectual property. And they invited 3 intellectual property attorneys and me as a practitioner. Not as a legal practitioner, but as a design practitioner. I'm an entrepreneur with a lot of experience with intellectual property. And the 3 attorneys gave their presentations, and it got to me. And the first thing I did was tell a lawyer joke. And one of the guys sitting in the audience, I told a lawyer joke, and then I said, everything these guys just told you is true, but and one of the people in the audience was a faculty member of the design department over here. And he said, we got to get this guy. So that's why I'm here. That being said, it gives me great pleasure to introduce one of my friends and colleagues from I don't know how many years ago, Rod Rigole. Rod Rigole wears many, many different things. He is an intellectual property attorney and an intellectual property attorney for the biggest video game companies in the world. He was corporate counsel for Vivendi Games, and then when they merged with Activision and became Activision Blizzard, Rod went on to Blizzard and became their corporate attorney, and has now moved on to Dreamhaven, which is Blizzard founders Mike or new venture. So Rod is now a startup attorney as well. Rod is also a property developer. He develops themed entertainment resorts, I guess, is that a good way to put it? Themed entertainment properties. He's an inventor and an entrepreneur. And I think I can think of no better person to come in here to talk to you about startup and about the value of protecting your intellectual property. And that being said, I'm going to get out of the way, let Rod take it. I'll be available for questions and maybe things
that is most important. Well, may remember judging the Apostle Business.
Oh yeah,
It's on my resume.
yes. Thanks, Rod.
To be informal, I'm kind of just going through a guide of kind of what some of the basic IP is, probably most people already know. But as we kind of go through it, if you have any questions, let's stop and ask, talk about questions and talk about different topics. This is, like I said, just meant to be a guide. It's kind of informal. You can't hear me, or if I talk too fast, sometimes I have this habit of talking incredibly fast. Just kind of tell me to slow down and we'll kind of go through it. So Steve did my introduction already. So I was going to tell you about what's not an existential type of question. Steve already filled in who I am. I've been a lawyer for 30 years now. I specialize in IP, but then kind of my bucket grew, handle transactions, privacy, and things like that. But my heart goes with IP just because I love protecting ideas. I love design. I love people's just creations. So that's kind of why I became an attorney. For you guys. So I'm going to go through the different types of IP. If you guys have any questions, just let me know. This is a repurposed presentation. To be honest, I don't even know what it's going to do. So if it does something weird, it was from like a decade ago, but updated. So the first one we're going to talk about is copyrights. So what is a copyright? So copyright is basically protects an original work's authorship. So you're thinking like so one thing that people get confused with is it doesn't protect ideas. Everyone goes like, hey, have a copyright. That protects the idea. For you guys, depending upon what you're developing, this is not necessarily the IP road you want to go down. Because everyone basically thinks, I copyright it. It's not going to protect the concept. It's fine. The common misconception. So what does it protect? So basically, it kind of protects original work of authorship, but once it's actually fixed in some type of tangible medium. So the second you draw a picture, the second you basically do a computer program, the second you basically write a novel, it's automatically protected by copyright. You don't have to register it. You don't have to put a C on it. It's yours. So in connection with that, like I said, is what does copyright protect? Computer programs, protects books, protects music, and it also protects pretty much anything that's original from authorship, sketches, whatever you took in your class. So copyright rights allow you to basically sell your work, distribute work, compare derivative work. So basically, if you make a modification of what you originally did, you own the right to that as well. And then importantly, the rights to publicly display it. So like, for instance, for music, if you're going into a bar or something like that in connection with public rights, that bar doesn't have the rights to play the radio or anything like that. It's right, it's open to copyright. So this is the important, yes.
Sorry, regarding copyright for something like a character, let's say you copyright an image or a sketch of that character. If someone else copies that character, but maybe like pose or in a different fashion, is that still illegal?
So we're gonna actually go through, you actually, thank you. So basically copyright infringement, so when somebody copies the character, like what does it mean to basically be copyright infringement? So basically a substantial similarity. So in your example, it's how close that character is. And then also it's whether or not that expression is original. So basically, if you take a mouse and you tweak a mouse, well, there's a lot of other mouses that are popular. So it's how original and how acceptable the expression is first, and then how close it is to the copy. So kind of to that point, substantial similarity is the one, how close is it? The person always had to have access to it, which is really easy because once it's out in the public, they have access. And then basically, as we already went through, has to be protectable expression. It has to be something that actually can have a copyright or is protectable. And then the key is audience reaction. So basically, people in the room, if you show up, because it's going to be in front of a jury, you're going to show up the two characters. How close are they? Does it really look like this has been copied? Does the one have more of an expression, looks different? That's actually a big factor, especially for juries. So I'm kind of going to go through some of the examples that I either worked on or actually is kind of inspired by my career. So kind of to the point of your copying. So here's two similar worlds. So basically Battlestar Galactica and Star Wars. Star Wars came out, was highly successful. Fox Studios came out with a television series called Battlestar Galactica. Star Wars, George Lucas sued 20th Century Fox because they copied it. So you kind of have to look at the two different parties. Once again, you can't protect an idea. Having people in space flying in spaceships and basically kind of a world order change where something is going to do that is not protectable. It's an idea, right? So it's actually how the expression of the idea is actually comes to play. And so what you have to do is you have to take the two different works and then really look at them and then figure out all the different elements that are copied or what makes that story different, and then look at the other one and whether or not it's. So to do that, to win the case for Star Wars, they would have to do a couple things. So first of all, they'd have to look at the elements at issue were original to them, because when you look at something, a lot of times it's not original. Like we were talking about a mouse. Tons of people have done mouse. Is a mouse protectable? Not going to be protected. Then whether or not those elements in the particular thing are actually similar. So does the mouse have horns? Does the mouse have a nose? Whatever it is. And then whether or not the other party copied those things. I will tell you that they didn't mean this. So it really was just an idea that was kind of similar. You kind of find that a lot in movies. Like if the ideas were protectable, like I can't remember which one, but sometimes during the same summer, you'll have two movies that are pretty much the exact same idea implemented. If you could copyright the particular movie, then the other movie would be infringing. Here's another example. So Vanilla Ice came out with a song that basically took a sampling of Queen song. I don't know if you guys will be updating myself, but Queen actually sued Vanilla Ice. And once again, you look at exactly kind of how much was copied. It was verbatim, and but it was a small snippet. There's a common misconception in IP circles that people go like, you can copy 8 notes. You can copy 10 notes. You can copy this much, like for sampling. There is no such rule. If basically it's discernible, it's copied, and basically it is, someone audience could basically say, yeah, that's exactly the same. It's copyright infringement. And this one, they basically settled out of court because he did commit copyright infringement. So this kind of a new topic. It's kind of interesting because AI. So basically, people are creating contracts. People are creating novels. People are creating original artwork using AI. But then who owns it? So you're putting inputs into a computer, and then it's spitting something out. So maybe you're saying, hey, control the color. Maybe I want it something like this, and all these different inputs. But then you're getting something that you would think that maybe, because it's once again, it's like a graphic, or maybe it's a music or something that would normally be ability to get a copyright, but is that protectable? Well, basically, right now, look at the Copyright Office came out about 2 weeks ago, it's not protectable. Because it wasn't created by a human. So it has to be created by a human because it protects original works of authorship, namely a person, not a computer. Even though that you're saying, hey, make it red, make it green, make it this, there's still not enough control to give you the copyright to that particular piece.
What if you do like an AI image of a character, and you use that character in like your own scripted movie, and then someone else uses that character, but the character was AI, but it's from the movie.
So, well, it's interesting. I think you actually have to go through another thing, what we're going to talk about, but the character would not be protected. So they could take the character and use it as they will, because the character is not allowed to get copyright protection. If you wanted to like protect that character, what the key is to actually have more input of yourselves. So basically it spits out a general, character. And what you do is you use your own artistic abilities to make that character your own. So you basically change things. You basically make it red. You do things that would actually cause creative expression, almost like you're creating it from scratch to give it protection.
Since there's no evidence that it was created via AI though, can't people just claim that they made it original?
That's a really good point. So honestly, it almost goes the other way, because what's going to happen is it's going to get out, because someone's going to sue you, and you're going to go to trial. You're going to have to stand under oath that you created this, original. Your assistant's going to go like, no, I saw him on the computer and he just put that in and do that. And then you're like, that's the way it's going to happen. So it's kind of the other way. What you do is you document what you put into it. So the reason what you made different. That's what is the key, is because everyone's going to say that it's AI. And what you have to do is go back and prove that you made it something special, that it wasn't just AI, it was part of your creation. So that's where it's going to be protected. Steve.
So Rod, do you think that decision by the Copyright Office will be challenged in court, and do you think it will hold up the challenge?
It's actually being challenged right now. Yeah, I think it actually is going to hold up, because I don't think that what they're trying to do is get rid of the human component, and that's the basis of copyright. So it's original creative expression, and a computer is not a form of original creative expression.
I think the counter argument to that is when I take a photograph, the machine is the one producing the image. So I make decisions about what the image will capture, and I think people will start looking at AI in a very similar way. Well, I'm still making decisions. So even a job description now called a prompt engineer, which is recognizing that it takes a certain type of effort and understanding to get an AI to produce something.
There was a case exactly like that. There was basically a novel that had pictures or AI generated, and the Copyright Office said no. Specifically, even though the other content was original, it had elements that were generated by AI. I don't think it's going to be like that. Like I will tell you, there's another case. There was a famous photographer who set up a camera. You may have heard of this as well, and set up with a bunch of apes. And the apes picked up the camera and they took pictures. And so the question was, who owns the copyright to that image? The photographer published it. Someone basically took the photograph and copied it, copied the character, and he sued for the copyright infringement. It came down, and actually the court was that a movie can't own the copyright. It has to be a human authorship for creative spirit. Even though he set up the tripod, he pointed in a general direction, he urged them to actually take photos, kind of made it a thing, but copyright didn't basically affect it. And that was actually before AI, and I think AI is going to go the same way.
I mean, when people do digital art, use their devices as tools, wouldn't you say that they could also use artificial intelligence as a tool to graph? So to what extent is the line this work?
For sure, and I think that that's the way it's going to be used. Is I think because it saves everything. Like in our field, with art, you basically create and then you create and you create and you create. With AI, you can create the original image, and then the computer will basically take it the next steps. But you created the original image. The original image was your protected work, and then the result of it would be protected. But I think that people are going to use AI, they need to be very carefully, is to use it as the base. So something spits out, and then you make it creative. So like if it spits out like a story, basically you can have your AI write a novel. You take that and embellish it with own blood center creative. You introduce characters, give characters names, you describe the characters, and then you make it your own, that would be protected. The same thing with an image. It's gonna be interesting, because this is brand new, like literally, I think it was 3 weeks ago that the Copyright Office actually opined on what, what the rule is, and the rules may change. But I think that the foundation, it's pretty much the foundation of copyright law, so I don't think it's gonna change that much. So at the end of each one of these, I'm just going to do like kind of a summary just to kind of go through it. So protects original form of authorship, not for ideas. Honestly, that is what it's not, because most people just have it. It's automatic. Once you do it, automatically protected. And then when it crosses the line, it's substantial. Please.
So assume I had some artistic talent, which I don't, and I created a character. Yes, technically it's copyrighted the day I created. What should I do to prove that I created it when?
Well, there's different ways. The best way to do it is if you're developing an IP and it's based for your movie, your novel, whatever it is, honestly register. That's the way basically it goes to the government, they put a stamp on it, and you have that date and time. Also, if you're going to sue anyone, you actually have to have it registered anyway. So it puts everybody on notice. The other way is to basically just document. So you can take a photo, whatever you can do, any way you can do. They used to call this thing called the poor man's patent, and some people did the same thing with copyright. You would put an image in an envelope and mail it to yourself, and then it had the stamp from the post office on it. And that was your evidence way of doing it. Nowadays, you have it on your computer file that's dated. There's so many other ways that you could prove, the authorship. So you could have it on your computer, you can mail it to yourself, you file a copyright registration.
I know in the music industry, a lot of people that write songs, that's what they always mail their songs when they're finished. It's to their attorney or something, just so they can have proof when they did it.
Anything, like it's basically at the point of a case, you have to prove that point in time and it was original. So you can give it to your attorney, like I said, a computer file, you can email it to somebody, you can email it to yourself. As long as there's some type of date stamp, usually it doesn't come down to that because it's a pretty clear, usually what happens when you mail it to yourself, no one has access to it. We kind of talked about access. And so it's going to be really hard for someone to steal it. What happens is that usually it's published. So you already have a date when it's published and becomes available to everybody. And then usually the person steals it after that date because then it's
Like, I'm pretty sure copyright has like a deadline or like it's like, for example, music. Like, how do we know that it's something too substantially similar to like music from like 2000 years?
But so it's a really good point. So there is an expiration date. So for corporations, I think the thing is 90 years. So you go So and then the life of the author plus I believe it's 70.
So even though the author original like
So
creator passed away.
if you went to 1,000 years ago, it's not going to be protected. They call it that's in the public domain. So literally it's out there. So if you take a song from the 1600s, 1700s, 1800s, it's yours. Like it's dedicated to the public at that point. You can do whatever you want.
I'm very curious because my best friend's like character artist. So I'm curious if anyone you've seen within your studio has been using AI images as like inspiration for character designs for the games that they're working on.
For me, so I worked for Blizzard for 20 years. AI wasn't even then for the most part. The AI, but not to create things. Now it's becoming issue we're looking. Just kind of seeing where it will end up, but I think it's going to be more when you create the character, because that's what you want. Your designers are, have a game, they have an idea, they're going to create it from scratch. And then I think where AI is going to come for us at least is that it's going to take that image or take that character and then make more. Will basically make an environment. It'll make that character do this character with like a weapon or whatever it is. The stuff that's very tedious and more laborious, that will be taken care of by AI. It'll be so much cheaper than like having the artist do it.
Well, I think it was like AI, I guess, but it's kind of code. So when you have like a computer system, a coding created, right? And that code does like a certain very specific task, and that's copyrighted. I've seen like, like with Instagram, they had the stories feature, but Snapchat had it first. So how does something go from like where is a line where it's like an idea and then where it's like a copyrighted function that another company cannot steal?
So with the code, it pretty much has, you can't protect an idea. So if I look at how something works and I code it differently, it copyright won't protect. But usually what happens with code is people steal the code. They literally copy it verbatim. It's really easy to see if you look up, they don't, most people who infringe code are lazy. They literally just take the exact code and you can look at one and it's stolen. And so if you, like for us in the software people, if you look at something, you're like, hey, I want it to do this. You have your engineer, people are very experienced coding, and that person will start afresh and he will make the code that works for that.
If you want to hear your perspective on AI copyright, but on the other side of it, because there's a big debate that AI is basically a database, everything copyrighted. So what do you think about that?
So that's really interesting, is because one of the AI engines was actually sued because what they did is they gave access to copyright images. So if something's protected, something can't use that as a basis. It can't analyze it. It can't do anything. It's basically protected. And so I don't know where that actually has gone. I think they settled, but you're not allowed to have an AI go through and look through copyrighted images and take images like that. It's basically copying, because what they do is they take it and they copy it out to basically process it. Copying is one of the rights that are protected under the copyright. You're not allowed to do that. But a lot of things, including Google, have allowed AI programmers, etc., to use their database to actually train AI. A lot of times it just depends on the field. Companies want AI and to actually learn, because they usually get the improvements as well. So people are more showing what they do and giving AI programmers access, so because they usually get the benefit. Okay, next one. So trademarks. So trademarks are basically can be anything that distinguishes one product. So most people think of it as a word. It could be a character name. It could be many, many different things, as long as it's used to distinguish your product from somebody else. So most people are surprised. It can be a sound. So Harley Davidson trademarked potato, 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 because that was the sound of their engine. There's so we'll get there in a second. So there's two types of trademarks. One's a registered trademark and the other one's common law. You go in front of the USPTO or whatever the world government is and you register your trademark. So what you're doing is you're claiming rights in that particular name, and then so that everybody else has notice of that. The other one is common law trademark. So similar to copyright, but a little bit more in depth. You get trademark protection by using the mark, but the rights are very limited. So it depends on the scope of how you're using it, what mark you're using. So it can be, say you have a burger place and you have it same Jack's or something in LA. Your trademark protection for common law is going to be limited to Jack's in LA. If you register it, then you basically have automatic protection for the. This is interesting. Everybody sees trademarks everywhere. Starbucks, Windows, Styrofoam. Like I said, some of the things that are interesting is that colors. So pink for insulation is that trademarked by Owens Corning. Pink isn't the normal color of insulation, it could be whatever it is. They basically use that to identify their company and their product. The chime sound, so when you hear NBC, whatever that is, way better than I. That's trademarked by NBC. Everybody hears that sound and it associates it with NBC and the peacock. And then smell. So there's a thread company that has scented thread that is associated with their company, and they trademark this particular smell, which I didn't know was Mary Blossom smell. That's what it was. So here's kind of what the yes.
Is trademark also similar to copyright in the sense of like the 90 years until like paying for installation, or that's it? Like,
Trademark you have ever. So as long as you basically continue to use the mark, and then if it's registered, you have to file certain things to keep it active. So between the 5th and 6th year, you have to say that it's continually used. And then at the 10th year, you have to basically file to say a renewal. So as long as you keep and maintain it and use it, it will last forever.
Does it cost a lot to maintain it or like file it?
Yeah, so filing for copyright is incredibly cheap. Trademark, incredibly cheap. You can, and it's, get a lawyer, not legal advice, but you can do it yourself. It's super easy. For a trademark register for application, it's $325.
And it lasts as long as the name, it lasts part.
You have to file, so like I said, between the 5th and the 6th year, you have to pay something, I can't remember, it's maybe $150, and then the 10th year you pay again, it's $100. So you think of like Disney, Disney is gonna be around forever, they're gonna keep that forever. And there's ones that are gonna be around for,
What do websites fall under?
let's say, what?
Website links, like, can you not trademark your website link, like a certain domain?
A domain or a link?
Like the website, like for example, like ross.com, no one can touch that.
Well, it kind of depends on what it is and what kind of talk about it. Trademarks have different strengths. And so it depends, because Ross, like I say, you're huge, for example, Ross, that's somebody's name. It's a character on Friends. You know, there's many different things that would be Ross. And so just because you have a business named Ross, you may not be entitled to the name. This has been, it's funny you say that, because it used to be very contentious, because when the internet when it came about, a lot of big companies were very slow to register their domain names, very slow. And so people and companies were registered by them. And what they did is they went to the companies and basically said, hey, listen, my name's Ross, you want Ross, that's gonna be $100 grand. And so they actually developed a whole case law that basically prohibited them. So you couldn't basically register domain names in bad faith and then hold the company hostage. Interesting. It's less, because now people are more sophisticated, so it happens less, but back in the day, it was the wild, wild west. So for, kind of, we talked about copyright, what crosses the line. This is what copyright crosses the line for trademark infringement. So it's confusingly similar. This is actually from a Supreme Court case that kind of defined what that means. And so there's various things. So you could have two names, but, and one thing is that whether or not they're sight, sound, and meaning. First thing, two words that are spelled exactly the same. Chances are there's going to be some type of confusion. So then you kind of look deeper. What products are they? If I am doing trucks, the other person's doing bread, chances are people are not going to be confused, because someone who manufactures trucks probably not going to be bread. Then you kind of look at the strength of the mark. So there's different levels of strengths of trademarks. If you're going to trademark something, the strongest place you can be is arbitrary or fanciful. So basically a made up word, like Google. Wasn't in the English language before they made it up. Xerox. Those are the strongest trademarks, because it doesn't, nothing even closer. It has a very, very specific meaning. The next one down from that is suggestive. So it really doesn't describe what it is. Actually, another for arbitrary. So made up, next strong. The next one is arbitrary, like Apple. The computer isn't an apple, but it's a real word. So it's arbitrary, very, very strong. Next level is suggestive. Like it tells you a little bit about maybe the product, what you're selling, but not exactly. And the lowest rung is descriptive. So really the word is only describing what the product is. And you can't really take away people's ability to use the English solution. So if something's blue, it's blue. If something's fast, it's fast. You can't basically protect that word and prevent anybody else from using a descriptive word. And the last danger, which you never want to be in, kind of trademark, is generic. That is actually not entitled. Remember I told you have to, it's something that identifies a specific product. The generic categories never want your product to go, because people cannot associate your product with that word. So escalator. Escalator was a trademark of a company in the past, but now anytime you're going up and down, that's an escalator. Phoenix has to fight fiercely to protect their trademark, because people, any type of bath dish, Costco, anybody, it's Kleenex. Xerox did the same thing, because anytime you went to copy machine, whether it was a Franken, whatever it is, people go like, I'm going to go Xerox this. So they would go out and for copy stores and say, hey, we're not using the correct terminology. We need to basically use it. They basically protected their mark so that people knew that it was their mark and it didn't become generic. Because your trademark for a company is one of the most valuable things you can have. You don't want it to become generic, because then it basically is meaningless, it's worthless.
I have a weird question, but say that the company gets here domestically and then move something to
website.
Does that trademark apply if some other company starts?
It's a really good question. So each country has their own trademark laws. So what you do if you're starting a company, if you broader scope, like if you're gonna market a product in 50 countries, you really where you want to protect. So you need to do two things. So let's kind of get a look. First of all, when you pick a name, you want to make sure no one else has it. Same reviews. You and for brilliant. So if you basically it's like, I got this great idea, I want to name my company Google without even knowing. There's probably a technique called Google. So you have to kind of figure it out to make sure. And that search goes worldwide. You want to make sure that somebody in the UK doesn't have the same market in the US, because honestly, you want your business to go to the UK, you want it to go to China, you want it to go to Australia. So getting a name that hasn't been used, it's not easy. It is not easy. We face that all the time in the video game space because there's so many video games, so many companies. It is very tough to pick a name that hasn't been taken. It's incredibly difficult. We go through hundreds and hundreds of names. That's why the best thing to do is, if you can, and it sounds okay, is to pick something that's completely original. First of all, you're gonna have less problems getting the trademark. And then also it's that's the strongest trademark you can possibly have, because you just need it.
That sounds like most of the drug companies.
Exactly. Some of the names that drug companies pick up, like you're just like, what the heck?
What's Ozempic?
Yes, yes. But it's interesting, like they're the marketing team that's coming, it's like, oh, did you remember that? That's probably the only one that
I don't know what it
remember.
does, but I remember it.
Yeah, and that's the most important. Is when you go to your doctor, once again, you want to identify the company and the product. So when you go to the doctor, you know exactly what that is. That's the goal of the marketing team. That's the strength of the brand. That's a strong.
You see the picture of trademark name, businesses naming ideas going in, because I feel like we all share the same problem of creating an original name for our startup. And I feel like to some extent down the line, we're gonna be like creating usernames at this point just for like our business.
It's incredibly, and it really is, especially one that you're proud of. Because what happens is usually pick 100 names, you're like, oh my gosh, 98 was the one that does. I hated that name. It's a really tough process. But what happens is that, remember we talked about how long a trademark lasts for? So people may have trademarked it in the past. A lot of, you guys know this, most businesses fail. Most products fail, right? And so a lot of trademarks that people have applied for, they're not using. So once somebody actually no longer uses, you have to kind of evaluate whether or not it's can use it. But once again, they've been around for 10 years, they didn't file a renewal. That may be free to use. So I think it's going to basically wash, rinse, repeat too, as people stop using trademarks.
There's a trademark in another country, but it's like, let's just say a business idea, the name of a business in another country, but it's not in the States at all. And you want to take that name, like as far as the US is concerned, like, can you still take that name of that business, but it's not registered in the States? It's like a really distant country, they're active, the relations with the States isn't the best, it doesn't matter, I guess. Like, I'm just asking, like, can you still do it? Is the US concerned with foreign trademarks, or you can take it, doesn't matter, right?
So the only thing the US looks at is their trademark registry. If it's not in there and they can't find it used in the US, they don't care.
Okay,
You may care.
right.
And the only reason why is because if you're going to expand to whatever that region is, they may prevent your expansion. So one thing too is company names aren't necessarily trademarks. So companies they go with the products, they trademark the products, that's what they're selling, that's what the consumers identify with. A lot of companies that actually produce these products, you may not know. And so it's not acting as a trademark because it's not used to identify the company or the product. Like you can name, and someone can't go after you for using the same name because you're not using the trademark. So if you had, I don't know, I'm trying to be some designer, DK, whatever, it's the name of the business, but you don't use it as your trademark, you don't put it on your products, you're not promoting it on your website, it's like that. You're not using it as a trademark. You're just using it as identifier. Maybe you have a check with it or whatever. You're not basically identifying your company or product with something that other people recognize. So you may be able to have a name of a company that someone else has, maybe a popular trademark, as long as you're not using it as a trademark.
I think it's a copyright question, but it pertains to the fashion industry. So like if a fashion company makes a design, is it automatically copyrighted under their like company? Because there have been like controversies where like a very like cheap fast fashion retailer will copy like, you know, like exact designs, like even the way they're like showing the model on their website.
No, it's copyright, that's another thing, so there's a couple of things. For fashion, copyright for one, right? But the thing is that a lot of things in fashion are not original. So you can only protect things that are original. And so a lot of fashion kind of recirculates, or people take little things of this, and so is it really an original expression? That's like first thing. What people did in the fashion industry do a lot of trademark. So all of a sudden, I think of the things like that blue stripe or whatever. So whatever the people use certain things, soles or a certain color, the red sole, whatever that product is, that becomes a trademark. It has no other function except to identify that particular product. So they use that as well. So use copyright for one, specific, kind of shape and stuff like that. And then they use trademark for a specific, first of all, they have the logo, but then also maybe red soles. And then they use something we're going to talk about in a second, which is actually the strongest one you can do for fashion. It's a design patent. And so we'll talk about that in a second. Fashion actually has many different kind of layers of protection. And they sue, like Walmart gets sued all of the time.
Yeah, I'm curious what you think like indie devs will be doing like 10 years from now when every game title name has ever been made and they're just a small indie dev and they're just trying to launch their game. What's your opinion on that?
So indie devs always get in trouble because they don't pay attention. So it's more of they just do things, like at least my experience with indie devs, they just kind of do it and then they take the repercussions later. But if somebody was diligent and was looking for a name, there's still names to have. Usually what happens is when you develop a game, you're coming up with a new world. You may be coming up with new terminology that you made up, or and so use that.
Company logo or like any brand logo that's considered as trademark that like once you create it, you have to register it in order to publish.
So you don't have to register it. So once you start to use it, if people, customers and your audience associate you with that particular mark, you don't have to register. It is smart to register. You automatically get rights. You don't have to put TM or anything like that. But that's belt and suspenders. You want to basically tell everyone, hey, I'm using this as a trademark for my product. And then what you want to do is, if you're just a logo, you want to register. If you want to, when someone's seeing if they can use a trademark, they're going to do two things. They're going to do a Google search, see what comes up, which most of the time it comes up that. Then they're going to look at the USPTO, the Patent and Trademark Office, to see if they see it, right? And if you registered it, it's going to be right there. There's no defense that they can actually have that they, it's right there. It's whatever goods you. But the one thing is, we're kind of talking about, we're kind of going through the thing, is for trademarks, you have to specify what goods you're using it for. So for Starbucks can't protect the colors. There's a whole nother thing to talk about, but Starbucks is for dishware, for coffee, for other things like that. That's their lane. They pretty much have to stay in their lane because that's what they file for and that's what they're protected. Because once again, it's what the consumer associates with them. So they associate Starbucks with coffee. They don't associate Starbucks with decent things. So it's very specific. When you have a trademark, you're kind of your lane is kind of what's protected. Kind of getting back to this. Sight, sound, and appearance, exactly like if you if I did Starbucks versus Starbucks, still protected. Any part of the word, anything else. The strength of the mark, we kind of talked about that. The proximity of the goods. So once again, it's your lane. So once again, if I have a video game company and I have a specific name, if someone does a video game title, video game service, or something like that, that's going to be protected. Someone uses the name that even I potentially came up with, or clothing or something like that, may not be protected because people aren't going to associate me with that particular product. It's so different.
But Starbucks would sue you anyway.
Starbucks would sue me in a hot second. And actually, they would probably have a good case because we're kind of talking about that as well, because there's a whole nother thing called dilution, which is a little bit harder. If someone has a mark which is too famous, which is these days, it's not easy to get. If you basically trade off their goodwill and diminish the value of their mark, it's called dilution, and they would go after you. So Starbucks, hands down, would satisfy the famous element of a mark, and they can be much more diligent. Me, a video game developer, if I have something else, probably not as much. And also usually what happens is that where it fails is people go beyond the name. So what they try to do is they try to get the logo listed. So there's a lot of other elements that people do that kind of cause it to be, more a target for Starbucks. So one of the things is, so the marketing channels of distribution, kind of the same thing with goods. If something's marketed in Walmart, but something is a very specialty store, you're only going to see it as like a pool supply or something like that. Different customers, chances are people are not going to get confused because people are looking at a certain thing. If I'm in a pool supply place and there's something that sounds a little bit similar to Starbucks and has a unique pool supply, I'm not going to think it's from Starbucks. Maybe Starbucks, maybe something like that. And then the likelihood of product expansion line. So we kind of talked about you stay in your lane, but how close is another line, right? So say Starbucks, if I was only doing coffee and I became really popular with coffee and everyone associated with coffee, would it be reasonable that I would go into tea or, other beverages like sodas and stuff like that? Probably, and Starbucks did. So you can actually flex your muscle a little bit and go into a place that is not your goods and services.
What if something like Marvel? I think that's one like 6 lines that wants to make a ride named after it, like the Batman. What is the situation with that, like the trade?
They license it all.
So that's the pay.
They do. So it's usually what happens is, once again, when you have a trademark, they associate it with the company that's doing it. So people associate that ride with Marvel. And so that's what's going to get them there. That's why people are paying money, because they're going to pay the extra money, because now people are going to want to go there to ride the Batman.
DC,
DC.
Marvel's DC.
You're right.
I mean, that.
Marvel is exactly DC.
Is an abbreviation of the name or game trademarked on a full name is, because you look at Blizzard, World of Warcraft, popular name, obviously trademark. There's an online game, multiplayer game, it's World of Warships. And it's also WoW if you abbreviate it. But WoW is so massively associated with World of Warcraft. How is that?
So the same couple of years, I sent them a letter. Very nice, I call it my nasty letter. So, so some of those companies, it depends on what happens is, if it was World of Warcraft and World of Warships, pretty strong, right? It's both a video game. What you have to do is you look at what other people are doing. In that particular case, there was world of this, world of that. Your mark is less strong. Once again, people can identify world of with just you. There's other people that use that. So that's the problem with World of Warships, is because there were other people that use world of. They had the war part, but different, it's a tough argument. WoW, on the other hand, is. So I will tell you that at Blizzard, we didn't use WoW when World of Warcraft came out, because somebody else was using WoW. So then what happened was that people associated Blizzard with WoW. That was, once again, anything that's used to basically identify your company or product. And then after that point, then we registered and then we kind of took over WoW.
Sort of like the World Wildlife Federation was able to make the World Wrestling Federation change their name because they're both WWF.
Exactly. That's a perfect case. So they basically had the exact same market with the same acronym, obviously different goods and services, but there was in connection with the marketplace, who was doing what, in connection with market. So I don't know if they changed their name. I think they still, but I think what happened is they reached in.
They went to WWE.
Yes, they did, but I think that there was a time that they used the same one, and I think they reached.
I wanted to ask, isn't the company a trademark base? For example, imagine a big company that originated in Europe came to branch out in the US and we find out that someone trademarked the same name, almost the same genre of products. Could they argue like more people know about us? Can we take the trademark?
It's not a take the trademark per se, because what happens is that trademark is time dependent. So who has the rights first? So if this small person in Mississippi who's been using the entire United States was 10 years before them, they're going to be really hard. What happens is if you have people about the same time, or what happens is the guy in Mississippi did it after, that's where things start to get a little bit, because was he inspired by this company in Europe, or would they expand in the US? So it gets a little bit dicey, but still, if they were marketing their product in the US, he was in Mississippi, he did it first, he has the rights. And actually, it happens quite often that somebody will have this, I've done it for my company, we go out and buy the rights to Clearways, because you can't find original names, all of a sudden you have somebody that potentially has the rights, you go buy it. And that's kind of, so usually big companies find the guy that's been using it for a long time and then go and buy it.
Person in Mississippi is only using it in the state of Mississippi. A European company.
So it depends. So if he's only using it in Mississippi and he didn't register it, theoretically, he can only use it in Mississippi. If he registered, he'd have to use it beyond Mississippi. To get a federal trademark registration, you have to use it in interstate commerce. So he would have to ship some to Alabama. But for the most part, if he registered it, he's covered everywhere. Here's some, I think, what we're talking about. So Apple Music, very iconic Beetle Bell production company, and then Apple Computers. They had a riff when Apple Computers came out, right? Mostly because of the same exact logo. Once again, it depends on the goods and services. So a computer company and a music production company, really not that similar, because the goods they do, but they used pretty much the exact same logo, so it's a problem. So they worked it out. They basically said, hey, listen, you stay in your lane, we're going to stay in our lane. Problem happened. Guess what happened? Apple went into music. They came back and said, hey, you crossed the line. Not only did you break your settlement agreement, now you're actually right in our sweet spot. And they ended up settling that. But this is actually one from my days of Blizzard. So we had Diablo, the computer game, role-playing game. And then New Line Cinema was coming up with a movie called Diablo. So we sued them. It was Vin Diesel, if anyone ever saw it, horrible movie. But we basically sued them because, once again, if people associate you with a particular product. At the time, Diablo was an incredibly popular video game. It's very common when we talk about expansion, very common for video games to go into movies. And so we sued New Line and then actually made them change the name. That's probably why you never heard of the Diablo movie, because it was called a man. So here's to your point in connection with kind of Starbucks. So Louis Vuitton, which is a play on, or my understanding is basically roasted chicken, right? So Louis Vuitton sued this company to change their name. So once again, it kind of depends on how much you take. Like, look at the logos, look at the lettering, look at everything, right? So it's a complete clear ripoff. So even though they're different, Louis Vuitton doesn't do chicken. I don't think they do chicken. It's a dilution case. Louis Vuitton is a very famous brand. They're trading off the goodwill. They used so many elements over the long to be. They changed their name, but they changed it to something that was almost the same. And they got sued. So trademark summary. So anything that's used to identify a product could be sound, could be smell, could be color, could be anything. And then you don't need to put a TM on it. Highly advised the register, but you don't need to. And then crosses line when it's completely simple.
During these suits for companies to change, if they're in you're right. Is it the goal of the company to crush the other company, or do they just say, or do they take your name or else?
So it depends. So really, you just want them to change. Really just, because you don't care about anything else. You want to protect your business. You just want them to change. That's the goal. It depends. Sometimes what happens is, remember we talked about that little individual that was in Mississippi, wherever it was, and that other company come. Sometimes it's not about just crushing them and making them stop. Now it's about paying. Like, somebody wants money. They're using this as an opportunity to basically cash out. Someone wants my name, and now it's worth potential profit. So there's different people have different motivations. But most large companies, I find, really just want to protect. Even if the person stops and says, like, when I was at Blizzard, if I send a letter to someone, they said, hey, I'll stop. I wasn't asking for money. It's like, just tell me you're gonna stop. It's only when they escalate it, we're like, oh, we're not gonna change. That's when the stakes rise.
I have a direct experience with that. I got a cease and desist from Nintendo. They were challenging a trademark that they thought it was too similar to. So, way we resolved it, and I got Nintendo to pay me about $20,000, not to change the name of my company, which I didn't do. I kept it the same, but to change it from a trademark to a service. And they were fine with that. So they challenged the trademark, but they were okay with the service mark. So I kept it as a service.
That's interesting. No, really interesting. To be honest,
And
it's
so they
something,
paid me.
no, I know, it's a little baffling.
How do trademarks work in mergers and acquisitions? What steps should they have? Should it be, what are the right steps to protect intellectual property? I'm back.
So the key thing is when you're going through, that's a huge pain for IP lawyers. What they do is the company that's being acquired lists all the IP, right? And so they list the copyrights and list the patents. There's a list of trademarks. And so you have to go through theoretically and vet each one to see. It also depends on the stage. If it's a multi-billion-dollar company, presumably it's been around forever. Trademarks and things like that are going to be very valid. They've been around for a long time. You can look at it. Everything's going to be fine. Copyrights are similar, especially if it's like Mickey Mouse or something like that. You're going to know. The interesting thing comes when it's a startup, or it's something that maybe hasn't even been released publicly, because then you have to do more digging, because it hasn't been made public, so people aren't going to object to the trade. They're not going to object to the copyright. They're not going to object to this recently infringed patent. That's when you really have to go and figure out what the value is, because if it's the technology that's patented, it may not have been tested yet. So that's the value you're paying for. You really do a lot of that, or it's the name, but the name hasn't been released. You're just like, this really is an amazing name. This is going to sell the product. People are going to associate it with whatever. But if it hasn't been made public and hasn't been challenged, you're going to have to investigate the trademark, because that's what you're giving quite a bit of.
Working big companies like EBS acquiring Credit Suisse, let's say they want to change Credit Suisse to the name of EBS. How would that work?
Do you mean like?
If the Credit Suisse name is trademarked, how would UPS go about converting that or like buying?
It's part of they're buying it as part of the acquisition. It would be listed of what the assets they're buying. And we'll just go with the new company, and then what the new company does. Remember, we talked about when people abandon marks. That's what happens here. No one's going to use Credit Suisse anymore. It's just going to go to the trademark graveyard, and then theoretically, someone 10, 20 years may pick it up.
I'm curious with the defamation, or like with the Louis Vuitton like chicken thing that you mentioned with like trademarks. Then with like copywriting, like, you know, like Disney's Winnie the Pooh, how like I'm pretty sure it's public now, and then they made like that horror movie. I don't know if you heard about it. It's like a Winnie the Pooh horror movie, right? And then that's why that's now public domain. But I'm wondering, like, can Disney still do defamation, or like there's that they're famous, you're hurting our brand, but that's okay for copyright, but it's not okay for trademark. You know what I mean?
Exactly. I mean, it is okay for copyright, because what happens is that you're giving somebody, this is exclusively yours for a certain amount of time. The other side of that is, if we're going to give you exclusive rights for that, you're only going to get it for a certain amount of time, and then it goes to the public. People can move it. Same thing with patents.
Can Disney trademark Winnie the Pooh somehow?
So
they do that.
So just so you know, that used to be 75 years, right? That's the thing. Disney is the one that lobbied it to increase the to specifically protect their IP. They can't really trademark something like that if actually they can, but not for using it. So say for instance that if I had a character like the polo, right? That's a trademark of Ralph Lauren. So it's a character, but they use it as a trademark to identify their specific goods, which are polo shirts.
So Mickey's pretty much trademarked. So I've heard conversation of people saying, wait till Mickey Mouse is public domain, watch out, but that's them.
Well, you have to use it to infringe a trademark, you have to use it as a trademark to identify a product or service. So if it's Mickey Mouse comes in public domain, you may have a problem putting on t-shirts or clothing or tennis shoes and things like that because Disney would be using it as a trademark. But if you made a movie that was a Mickey Mouse, he's in the public domain, you can do whatever you want.
Okay.
It's the funny thing is that nowadays, like this is the only time this year that we've had this because now things are expiring that are valuable. People have had stuff in the 1800s or whatever it is, and it came into the public domain, like mostly books. And so when you read of those books that you get for super cheap paperback because they're already in the public domain, they don't have to pay anything. They just keep doing it. But it wasn't that prevalent. So now all of this really valuable IP is coming into the public domain. So it's gonna be super interesting.
Curiosity regarding AI, so it's become something that's super popular, which is to clone someone's face movements, like make them look like they're speaking, make them and copy their voice as well, and make them say whatever you want. So where's the line crossed on that? Is that trademark or copyright? That's technically the person's not registered, but Disney can copy the movie and make him alive again.
So part of it,
He ain't dead.
so part of it would be copyright. Because what they do is they took an image from a film and basically made this, so it would be copyright. A lot of times people don't do it, so it's kind of to your other point, like say it's not something that's a film or whatever, say it's a person or whatever it is. So there's a whole nother area of IP that's quite illicit. So if I'm a very famous person, someone who basically recreated my character and they're using it for a commercial purpose or something like that, then I have rights as well. So there's a lot of different those types of things, and then there's, I mean, those types of things are sort of fraud, there's other things, because usually it's kind of a derogatory thing to the person, so there's a whole bunch of other things.
So I have like kind of like a stipulation.
I've
I'm
never
like
assumed
so confused about trademark and copyright and whatnot. And you say music and copyright, right?
Yes.
Any songs and stuff? Any songs and everything?
Songs, lyrics,
Yeah, so
instrumental.
like, do you know that incident regarding Taylor Swift, the producer of Taylor Swift
Yes.
taking all of her old songs?
Yep.
So she made a whole new Taylor Swift edition in the new album. I just never understood why that happened.
Sure, so for recordings, there's a couple of different ways that the pie is split. So you have a person who, is the musician who's playing it, who's doing all that, that's like half the pie.
Right.
The other half of the pie, somebody is sitting there with the recording, and they own these rights. And so what happened in Taylor Swift's case, so like, she basically, the person, I can't remember, what's the guy's name that's her old
Right.
manager? Yes, so basically he bought her music catalog, right? So he bought recording, remember copyright goes once it's a fixed type of medium, so these are the recordings, it's fixed.
Even though she has an original copy.
So what happens, is he owns you have the right to reproduce copies of it. He owns those rights with respect to that specific recording. So what she did, and she was brilliant, to be honest, she goes, screw you, I'm gonna re-record it. I have all the rights to be, remember I told you the other half of the pie? She had those rights. She had the rights to the lyrics and the instrumental and all that stuff. That was her. So you just said, you know what? I'm just gonna re-record it. In her case, she had such a big following, people didn't really care if it was original versus this. Like people are like, I'm gonna listen to the ones that you newly recorded. I think it's better. So that's kind of like, there's two different rights in connection with musical recordings. Honestly, it was a brilliant.
You were working at Blizzard, scenarios in which change. What we're seeing.
Yeah, so that movie. So literally, usually I start off very nice. Sweet, nice person. And then it escalates. At Blizzard, my nickname is the Hammer, because then it turns. And so with New Line, I talked to their general counsel and he said, I get it. I completely understand. I get the fact there'd be confusion. He goes, let me talk to my guys and don't worry about it. Back a month later, he said, we're not changing. And so what happened is we had to sue them. Like I literally went through, and to be honest, it's not easy in the film industry because movie names aren't necessarily copyrighted. I mean, not a trademark. Usually for movies and for books, you have to have a series of them because it's, once again, it's supposed to associate you with a specific product or service. With one descriptive title, it doesn't really work. We won a preliminary injunction, which means they had to stop moving fast, which is really rare. And so there's other things that basically you have to show. Once again, everybody is going to associate this movie with your product. And that's what we show.
Were there any other instances besides that? Maybe?
Most of the other people stop. To be honest, because one thing too is it depends on how strong the trademark is. A lot of ours were just incredibly strong. Like we've been doing 5 products at different iterations, different expansions for a long time, and so they're, you know, the strength of the market was proven. All the consumers that are in that particular field know that that's a product. So it was a tough one for anyone to really do. The only way they would do is they would think that we would know where they were. And once we found them and knocked on their door, then they changed.
I know you said you were nice and whatnot, but do
Absolutely.
you have to be nice? Like the second, is there like a thing where it's like you have to notify first and they have maybe 30 days, or is it, oh, you took the name, sued, done, like that? Like, you know what I mean? Like, is there a little bit of space so that
You can do it however you want it. So the reason why I liked my approach, and I'll give you a kind of a story of what I used to do, is because I don't want to waste money on attorneys. Like, I don't want the time, I don't want to spend the money, I want it to resolve as quickly as possible. So if I call the person, I didn't even, really, if I have the person's phone number, I'm gonna say, hey, I'm Rod Rigole with Blizzard. I see that you're doing XYZ, I'm gonna ask you to stop. And so a lot of times that's effective. If you search my name on the internet, you can see a lot of things because people go, shit, I just had this visit, but you know, like it happened a lot. So for copyright protection, I'm kind of giving you an example of what I used to do. We used to have a lot of people who would do software, would do hacks and cheats constantly. So what I did is I did a thing called, I called it the knock and talk. So I would go and I would travel the world and I'd have a complaint already prepared file, and I would literally show up at the guy's door, unannounced, knock on the door, and I said, you probably don't know who I am. And then there for the next hour, they would sign a settlement agreement. I would take all of their computer stuff with me, and then it would resolve. And the reason why we did that is once super cheap, you know what I mean? It's just me flying on a plane to wherever. And then the other reason why is because we wanted to keep it. We didn't want people to all of a sudden go like, hey, this guy's out, and so we're going to be the next this, we're going to be the next that. And so for Lily, I did it in ways. First time it lasted about a year. Everything was quiet. Then it started to go again, I did it again, it lasted about another year. So I did that pretty much my entire career.
So a game like Call of Duty, where people are constantly hacking those games, you just go knock on that person's door and you say, you better quit or we're gonna sue you. What grounds do you have?
You show up with a complaint and say, this is a courtesy copy. This is going to be filed tomorrow. If you don't cooperate. And so there's like,
What grounds do you have to sue them?
for copyright. A clear cut, because usually what happens when people do a hack, they take pieces of your code. There's also another area about the Digital Millennium Copyright Act, which doesn't allow you to circumvent any protections you put in place. So people basically, when they hack, they go through your code and have to do some things to basically break the code for it to go. So
Let's say like there's a phrase on a website that I like, right? And the phrase itself isn't trademarked or copyrighted, right? But at the bottom of the website says so-and-so company with a C, right? Does that mean all the text and all the phrases that are on that web page are copyrighted by them?
So it could be. Most of the time, what happens when people think it's kind of a CYA. And usually they put, you know, and others or whatever it is, because sometimes you'll cover other people's stuff. Maybe it's a news site that has, you know, materials from other, they don't own the copyright to that. So it doesn't necessarily mean that they own everything. And once again, you don't have to put the C for it to be that. Like it is not a requirement. And so your phrase, like there's no trademark on it. So, but once again, you don't have to put the trademark on it to be protected. What you have to look for is, are people identifying that with the company? Like pick a famous phrase that's associated with the company. You're going to know, oh, that even though there's no TM, there's nothing on it, they're going to claim rights in that, even if they don't list it because it's associated with the company. If it's something that's descriptive, like it's just something like that describes a product, you can't get a trademark. Remember, that's like the weakest thing to do is descriptive, and you usually can't get copyright to phrases. It has to be something a little bit more robust. Like it's, you know, trademark is a thing for a sentence. Product is
So weird curiosity, I'm still not over the fact that someone trademarked scent. Like, how do you go about the process of putting that on paper and registering the trademark?
You describe it. So like that, I can't remember what it was, but it's like whatever blossom. And the thing with sounds or other things that are a little bit not like a word, it's tougher to get protection because they're gonna question it. Because the whole purpose of a trademark is to identify a product or service with that particular word. So you have to go, we're gonna make you go back and say like, hey, how do people associate that scent with your product? So you can't just go like, I'm gonna pick, you know, the smell of bleach for my whatever it is, I'm gonna trade. You literally have to have consumers that associate whatever product it is with that.
I'm a bit confused on the copyright expiration timeline because, for example, I know, you can explain a little bit about the happy birthday song. But I know when I worked as a waitress, we weren't allowed to use that specific song. Like we had to sing our own interpretation. But I know that song like dates back to like 18th century or something.
I don't think it dates back that long. I think the version that we all sing is relatively modern. I'd have to look into it. My understanding at one time, Michael Jackson. So I don't know if that's true. I never did the research, but you know, and that's why I know most restaurants change it. I think now that it's dedicated, I don't think it's in the public domain per se, but I think that they dedicated it to the public. I can't remember. There was some article I read like a couple of years ago that said that they weren't going to enforce it. But you know, once again, it protects any original work of authorship, and those rights last a long time. And I don't think that that is old as you. The patents. This is probably some of the most valuable IP that you can have for a company, because it gives you the exclusive right to basically make, sell, reproduce your product. Potentially keep competitors out for, say, software products and everything. Really, really valuable. So a patent is like a deed to your house. You own these four corners. Everything that's in those four corners, what we call a scope, that's what you own. Anybody goes into your wheelhouse, into your scope, that's infringement. So a patent, when it talks about what's basically making, using, or selling something. You could prohibit that from making it infringement. There's three different types of patents: utility, design, and patents. And patents are really what they are. Basically, fixing two different things, creating new plants. But we're not going to talk about that. But we're going to talk about utility and design. Utility is the one that you see most often. It pretty much protects. When we talked about copyright doesn't protect ideas, patents are exactly that. They protect ideas. What is a utility patent? So there's kind of 5 different categories. It's a process, it's a machine, it's an article of manufacture, it's a composition of matter, or it's an improvement on any of those. So patents, I always like to think the simplest and the most basic are the, like, why didn't I think of that? Almost always the most valuable. Like I always bring this in, like been doing it for years now, and so I've thought this stuff too. This may not be, but this is what the patent is. So people are obviously you're grabbing your coffee, like, oh my God, that's so hot. Wouldn't it be great if somebody's like, how about an insulated sleeve to put on? So somebody patented this, right? The scope of this whole, depending on how broad the patent is or how narrow the patent is, every time someone does this, they would have to pay royalties to the person who came up with this. The problem with patent, when we're talking about it, is a lot of people, when they do patents, they're very narrow. Remember I talked about the scope of it? So if somebody patented the scope, but they made it very specific, like inside I have triangular sleeve or something like this, and makes it very narrow, then what happens is anybody who does something different is an infringement. So we always talk about the concept of designing around. That's what they're doing, is they're looking at what's protected. They're going like, hey, I can do the same thing, but do it this way. Almost like we were talking about code. Like, hey, this is what I want to do. I want to make sure that it's not hot on the particular cup, but I'm going to do it a different way. Some of the patents are incredibly silly, right? So this is to basically where you're shaving, you have a mirrored side. If you look up stupid patents or ridiculous patents, you're going to get a whole shred. But who knows? This is actually one that we worked for my prior company. So back in the day when you guys were not born, is when you played a video game, is you used to have a joystick and you would run into things. And instead of going, you have to literally move around obstacles, right? my prior company, Sierra Online, basically said, hey, why, it kind of takes away from the game to try to move around things. Why don't you have an intelligent mover system where when you're going from spot A to B, it automatically goes around. So that was like 93. But the scope of what you can patent is pretty broad. Software, articles of manufacture, it protects the idea itself, and that's what you really, really want to prevent competition. We're going to talk about design patents, and this is a big one. Oh,
It's the expiration on utility patent. There is one, right?
yeah, I think it's 17 years for the data file. I have to brush up on it, but I believe it's 17 years for the data.
Then can you like re-patent a utility if you like changed it again slightly and then like keep it going, like loopholes like that?
So it's not necessarily loophole, but remember you can do any improvements. So what happens is as you evolve, you're going to make it better. And so you can patent the improvement, but once that underlying patent expires, that's free to the public. They just can't infringe upon your. So there used to be a thing called subrogating patents, which the person who developed laser was notorious for this. And so what it was, and kind of exactly what you said, what happens is that you file a patent, you can do another thing called a continuation, which is kind of an improvement, but and this person kept on doing it, but you never knew what the patent was because then it would be infringing and then it would issue, and then he kept on doing it. And it was a very interesting strategy they've heard since then, but it kind of was the same philosophy we talked about. So design patents, very important for fashion, but for many, many different things. So design patent is, so we talked about like regular patent, utility patent, really it's more about function, it's about the idea. This for design patent is about the aesthetic, right? So it's how it looks. You can't get a design patent in something that's function, that serves as a function. It's only the ornamental design piece of it. It's also lowest 14, but very, very valuable. So Apple sued Samsung in connection with the design patent and other patents for basically infringing their design for the iPhone. You can actually see their design patent. If you remember correctly, Samsung was pretty much spot on, right? Had the same mechanism, same rounded design, and Apple won over $500 million from Samsung. Yeah, a lot of money. There was some back and forth, and then finally they settled. But just in connection with another aspect to protect ornamental design or what's really associated with the product, because in Apple, no one beats Apple One design. Like just in connection with the way they design products and things of that nature, like just this, and it's really to prevent your competition. Okay, patent infringement. So to infringe, once again, you fall within the scope. So once again, the deeds, the four corners, when you make a product, it falls within the scope, and the scope is defined by claims. Like you say, it does this, 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 A, B, C, and D. And so when the infringing product does A, B, C, and D, that's what it is.
So for something like cars, every time a new car is released, are they filing a design patent every single time?
So it's interesting. So one for cars, once again, it can't be functional, right? So the element can't be functional. So a lot of things with cars, and same thing with I don't know, but it has to be ornamental. So some things, yes. So and actually, it's also a part of utility design patents and trademarks are similar, or can be similar. Like for instance, the grill of a Jeep is protected because people associate that particular grill with Jeeps. When I was at the video game company, we made video games that include cars and weapons and things of that nature. And so we were very careful because like for a design patent, it has to be ornamental, it can't serve a function. So in connection with the way guns, cars are designed, that is a complete function. Wheels are round, it has to be a certain height, this and that. And so that's not protectable in actually trademark order.
In the case of the Jeep, wouldn't that be considered trade dress?
Yeah, basically. Trade dress is similar to trademark. It's basically another way, instead of a name or something like that too, it's basically how something looks that associates it with your.
Which in that case would be more valuable than. Because it's associated with the brand as opposed to.
It depends, right? So the design patent for Apple was 500 million, right? So because it defined the product and people associated that with their product. But in connection, the good thing about it, so the design patent only lasts 14 years. Trade dress lasts forever when people associate. That's really good.
I'm assuming patents only limit the ideas to the United States. So what about like the companies or factories that have maybe something to do with the
So very similar to trademark, you have to file for patent protection in every country. Like if you're gonna market in that country, and that's gonna be a big market for you, that's really what you're gonna do. In connection with China, so China is they're coming around a little bit. It was very hard to get IP protection in China. It's a little easier, but that doesn't prevent people from copying you. So what happens is that the person can manufacture it in China and they can infringe your patent or whatever. Maybe you don't have protection, maybe you do, they're gonna do what they're gonna do, right? What happens is that people come to the United States. So once they come into the borders, you have your patent. Remember, you have the ability to prevent someone from making, using, or selling. So once they come in, they can't make, they can't use, they can't sell. So theoretically, they should not be able to sell to anybody in the United States. And usually what happens in that situation, which we did too, is if you have somebody that's a product that's being infringed a lot, you go to all of the different basically ports and you work with immigration and you basically educate them in connection with what your product is. So anytime they come on the boat, airplane, or whatever it is, they stop them. So you have a whole enforcement strategy where you basically stop it from even entering it. So patent summary. So once again, it's for an idea. It is set out to what's owned. So the claims, like what the four corners of your deed is, and then it's infringing when it falls within the claims. These are two bonus ones. So we talked about for IP, so trade secrets. So trade secrets are basically in non-disclosure agreement, very similar. So trade secret is something that is your right, like it's a recipe or something else that never gets out. Your company considers it so valuable, like the recipe to Coke is the most famous, right? So it's something that's incredibly valuable to your company that you don't disclose or give to anybody outside of a small circle. You really control it. And the reason why that's important is because if it does get out for whatever reason, so steal it or whatever, you still have IP rights in connection with that because it is your trade secret. And the other one is non-disclosure agreement. So people are afraid to give people their ideas. And sometimes it'll work, because you don't want to share what you think people are going to steal it. So the other area of just IP protection in general is just a simple non-disclosure agreement, which basically says you're going to keep it secret and you can't do anything with my idea. And then to some degree, if you're going to file for patent protection, you have to do that anyway, because one of the bars to patents is if it's public, if it's out in public, where you file for a certain period of time.
Now, what happens when someone kind of says, just forget it, I'm gonna go on Reddit and I'm just gonna leak this? Then what? Are you able to then just take it off the internet? Like,
so unfortunately, you can make Reddit, send Reddit letter or call them usually instantly and say, hey, listen, they'll remove it. What I found, depending on what it is, once it's out, it's out. Like that's the problem. It's just somebody else, copied it, someone else reposted it, someone did this, and it is a futile effort. It's whack. It's here, and you can do that. Just at some point, it's exhausting. And it's not going to matter. But the person who posted it, they can be in trouble. So basically, if it causes you damage, you could sue them for.
I just thought of like the Facebook Mark Zuckerberg case where like he kind of took two, I think they were rowers ideas of Facebook at first.
Yeah.
Yeah, how come he won? Like I don't really remember, like, do you break that down?
Yeah, in a couple of jurisdictions too, primarily where there's a lot of entertainment, like business, California, New York, there's a whole area of basically protection for unprotectable ideas. So even though you may not have a patent on it, you don't have enough information, you don't have enough like meat on the bone to actually get copyright. You don't have a trademark. But what happened is you have some type of proprietary interest in that because it's valuable. So I pitched it to some company or Hollywood studio, and all of a sudden they took my idea, right? It's more of an equity type of thing, and most of those claims are actually state-based versus some of these things. These are mostly federal, but those are state-based, and this is just so that someone doesn't do something that's unjust. So in that particular case, it kind of, I don't know if they had a written agreement, I can't remember the whole story, but, he was creating their product. They were giving him the things, why don't you do this, they were paying him, and so that's where it was, it was basically their baby, they did it, he stole the idea. Theoretically, so, and I don't know, usually when you do that type of thing, and I don't know they were in, at Harvard or whatever it is, but usually when you have someone build something for you, you have an agreement. Usually the agreement says, whatever you do, I own. Like it's called a work for hire agreement. And so I don't know if they had that type of agreement or whatever it is, but the understanding was that everything that he was doing was for their benefit.
It's not.
Well, I think they did pretty well. So. A lot of times in those situations is you have the idea, you have the thing. Someone else has, it is not easy to make a business successful. It's not easy to make a movie successful. It's not easy to do any of that stuff. And so you have somebody who had the idea, and then you have someone that really had the oomph behind it to make it successful. And that. I know that. Any questions? I did. And yeah, you're more than welcome to ask questions, like to me off this. Like I love ideas and I love the creative process. So you're more than welcome to reach out to me directly.
Right, can you address the issue of copyright?
You joining together, like
Doing authorship, because as far as I understand, if the work is jointly authored, if each author independently has the opportunity to exploit the work without the permission of the publisher.
exactly. So if you file something, you have joint copyright ownership, you get to do whatever you want to do. Usually what happens in that situation, you want to prevent that because obviously you want to work as a team and you don't want people to basically exploit it separately and undercut each other. It's just a horrible situation. You have an agreement in connection with how the rights are explained. But yeah, theoretically, and that's what happens a lot of times is people are great friends until they're not. And so you have two people that create, and then all of a sudden each person has ownership in this potentially amazing IP. Who's going to control it? What's going to happen? And it gets to be quite ugly. And then you have, it breaks down, and then you have arguments of who created what, and then it becomes.
Not copyright related, but what was your most memorable moment? Yes.
Yeah. I miss it so much with those knock and talks. Like literally, like it was the first year I covered the entire United States, and it lasted about a year. Like I would just show up at people, and then people in Europe would go, "There's no way he's gonna come. There's no way. We're just gonna infringe. We're gonna infringe. We're gonna infringe." And I showed up at their doorstep. And so then it had this chilling effect in Europe. Literally, I was in a different country every like 2 days, and it was fun. And then all of a sudden, the same thing happened outside Europe. So someone in Africa was like, "There's no way he's going to show up here. We're in this little program, And there I went. So it was every couple of years I had an amazing little world travel tour going to see people. And some people, and actually some funny story that I can share, but some people were ready for. I literally one time I arrived, it was in South Africa, and the guy had his computers all ready. He literally said, "I knew you were coming," and he literally just handed them over.
You made them an offer they couldn't refuse.
Well, I start off nice.
Mentioned copyright, and you mentioned. What's the difference in you patent something versus?
Sure, so especially it's very important for software. So once again, copyright only covers that expression. So someone has to copy. So we talked about how to get around that. So if if a routine does a specific thing, I can have my designer just do it a different way. Patent, on the other hand, protects the idea. So no matter how you do it, if it does within these things. So the best thing you can do is get a patent. There was a time where software was not patentable, and it's kind of made an evolution of what
I'm curious how you got your position with Blizzard and like and started and got to be where you were. What?
I'm not kidding. It is being in the right place at the right time. Literally, it was just being in the right place. And I was there for. So I had a good opportunity for the predecessor of Blizzard, and then Blizzard was another company that I went to Blizzard. And so I did a lot of a lot of people I know, I teach a similar course to this at some law schools, and people ask that, like, how do you get with the people? And it's, especially in certain industries, so impacted, everybody wants to be able to do it. I'm not kidding, everybody that's, they can do that, that's what they want to do. And it's just, you have to work really hard, right? And then you have to kind of show yourself a little bit different than the other person, and this applies to anything. And then it's just being in the right place.
That's the importance of networking.
You're absolutely right. Literally, networking is incredibly important for any type of business or anything. Even actually doing your business, like, oh my God, I talked to this person, and that person could open this door. And I do that every day. So if we're doing something or researching something, and you know, I ping my network to find out information that I may not know because they're internal to another company. And then, you know, or if we're going to release a product or something like that, then we reach out to them. And then, you know, the interesting thing is the longer you're doing it, the bigger. So the person who has the most Rolodex cards in the Rolodex, which is, you know, one of my bosses, carry a lot of power. You guys don't know what Rolodex is. I just thought of that as I said that.
Yeah, you wanna feel old.
Yeah.
They'll look at you like, what are you talking about?
I'm curious what years you worked at Blizzard and acting keep.
So I started with a parent of 90, and then I went to my new company in 2000. So I was there a long time. Actually, Steve and I worked together at Vivendi. 2004, 2005.
I was there around 2005. No, it was longer than that, or maybe longer than that. I think I left in 2008. 2008 is when the merger happened. Yeah. And that's when I left. So, yeah. So you went to Blizzard technically in 2008. Because prior to that, you were with Vivendi. Prior to that, were you Sierra before presenting you?
I was on the Call of Duty side, so my coworkers were on the Call of Duty side. That was one of my games. Like, I like to play, but I was.
Can you tell us a little bit about your non-legal ventures?
So I working as a lawyer for a big company is amazing. So if you're a lawyer, you don't want to be anywhere. It doesn't allow you to be as creative. And so on the side, I came up in college with a body surfing device. So basically this fin strap to your body called body fin, trademark. That was my first little venture. And then helped other different people. I came out with a instant hot beverage for Starbucks. They never went with, but literally you hit a button and it heated up. But I love, the only reason why I became a trainee is because I love people like this. I love interesting ideas. Worked with a couple of different products, but right now I run a themed bed and breakfast up in the wine country. So it has 8 rooms. I'm working on a alien-inspired motel near Joshua Tree. Just called Area 52. Oh my God. And it'll give me like 4 years. Those are my passions, allow me to be creative. If I had my best job ever, I would like to help people license products to major corporations. Just because I love people's ideas and it's networking, it's it's knowing how to do things. That would be my
Question of sorts.
yes.
I'm imagining someone who works with trademarks and patents to be very limited creatively, because I would imagine like, oh, what if this happens, and then someone already did. So like, how no, what is the question? This where I was going somewhere. Yeah, how do you deal with it like day to day? Like I can't imagine like being someone so creative and then dealing with all of this patents and this whole trademark world and knowing that there's something for everything.
We were having a discussion earlier. We recognized one another, but she did not think that I was a lawyer because it didn't seem like a lawyer. It's true. So working in the video game space, I get to be creative, say, work with really creative people. But that's why I have my sense. I love like conventions. I love like creative. That's kind of where I get the passion. Right brain.
I'd like to counter that though also because, you know, Albert Einstein started his career working in the Swiss patent office as a patent examiner. So it's all of the was read and evaluate patents. And I think it's a great spark. For creativity. And when you learn how to read a patent, you know, and get into details, it's really, really astounding. They're incredibly intricate. And, you know, Rod was talking about the claims, understanding specifics of the claims, which are the of the patent, really challenging.
Honestly, if you've never looked at a patent, pull one up because you will not understand. I guarantee you, they're written in a very obscure, very technical manner. They're really difficult. I'm a patent attorney, and honestly, you know, like it is very difficult to follow, difficult to discern, and it's read one because they're before you go to bed.
Is that because in court, it's very convenient to say that you meant something instead of how other people may have?
It's more just because it's a very difficult way of writing. So here's a perfect example. You've ever looked at a property? Southwest corner to this point, to this point, to this. It is really a description of what in the four corners of the property. Sometimes it used to be like you take 30 paces from this rock to this tree. I mean, it's really detailed. That's what a patent does, except it's for your idea. And so it's incredibly difficult to do. And we're talking about new original things as well. So not only do you have to come up with your idea, you have to differentiate your idea from everybody else's idea. So you have to say, hey, this is what I'm claiming. You know, I don't want, you know, I'm not claiming any of this stuff that these other people are doing or that this stuff that's, you know, obvious. We should kind of talk about where it is. Like one of the things for a patent to get protection, it has to be non-obvious. So you have to prove why this is non-obvious, and then also that somebody else didn't do it for you. And so the language they use to kind of achieve that and describe it is very difficult. In patent lawyers have very specific, they're trained to write in a certain way. It's not. It's very.
Which, by the way, is one of the reasons, even though you can file patents on your own, I would never recommend you take patents. Because you can write a patent with claims that are absolutely worthless. And I think another common practice is to file a provisional patent, thinking that, okay, this is a cheap, quick way to get my property covered, but a provisional patent can be worthless. Right? So, and I think the main reason for that is that the claims in a provisional patent have to be substantially similar to claims that you ultimately file. So you might as well just write the claims.
So I'm a patent attorney. When I did my patents, I hired a patent. Because I do a bunch of different IP and I work with video companies for years. So day to day, I'm not a patent attorney. So when I did my patent, I hired somebody else because it's really important. But the sad thing is you see a lot of these invention submission corporations and other things like, I'm going to help you with the idea. And a lot of times you go through this process, they're just money grabs. So what they do is even the things they do, like they give a patent, they're really worthless. They're not. Patent is something really, it is the foundation of the company technology. And so really important to get a great patent attorney.
You know how you mentioned with like indie artists or like developers, how they're just, you know, they might not have the money to get like someone like you who like advise them and go through like the ideas, like shutting it down, like you mentioned. Like, is your honest advice kind of for them to just do it, deal with it later? Because like I've heard that as well, where it's like at that point, or it's to get the ball rolling, then if you do step, you're gonna step on those toes, you're gonna cross boundaries, but you gotta start somewhere. So I mean, I'm not saying get sued later, but I kind of am.
No, I totally, to be honest with you. And the reason why is you're doing the whole thing to develop something valuable. When you run into that problem, they took all the value. So however your product worked, you can't do that way anymore because you're infringing patent. That name that is actually everyone's trying to associate with your video game that you just did, guess what? You can't use that name. So honestly, I think the IP protection is well worth it. It's something that's really important. you can base it out, especially because you don't need it until you're releasing the product. I mean, you want to just make sure that you don't disclose everything as secret as possible, and you kind of kick it back a little bit until you have the funds, but IP protection is incredibly, because that's really what the point is. Protection, like it's a product, it's a service, it's something, you want to basically have, so when you're in M&A, when someone's gonna pay $4.5 billion for your company, you're selling them something of value. And all of this IP protection prevents people from copycatting. And I'll tell you that we deal with venture capital all the time. When they invest in you, that's one of the things they look at. How easy is this going to be copycatted? Potentially with a better team, potentially better funding. And if someone can really come in and copycat you, it's a little more difficult, especially in this.
Along those lines, the other thing I want to know, even if you invest the money in intellectual property protection, and you have a great patent, if you don't have the money to enforce that patent, nobody